PMLA, a law that has lost its way. This is the topic that we are going to discuss today. In fact, I believe that all of you are very much aware of the Prevention of Money Laundering Act. And you are also very much aware of the Enforcement Directorate. And you are also very much aware of the criticism of politicization of PMLA and Enforcement Directorate. The question we are going to ask at this point in time is whether the purpose for which the PMLA was enacted, whether that purpose is being achieved or the PMLA is misused for political purposes. In order to understand this particular issue, it is necessary to know the genesis or history of PMLA. The genesis or the history of PMLA. To summarize the history, this Prevention of Money Laundering Act was enacted by the Indian Parliament in order to address the problem of money laundering which happened because of drug trafficking. So, the fundamental idea behind this law was drug trade. This drug trade leads to proceeds of crime, isn't it? When you sell drugs, definitely you will have proceeds, which is money or any other form of wealth. Drug trade is a crime. Proceeds of crime. This proceeds of crime can be laundered. What is the meaning of laundering? Laundering means converting an illegal property to a legal property. Money laundering. In fact, the word money laundering has a history in the sense that in late 1930s in USA, the USA government has imposed prohibition. Prohibition means liquor ban, because that was the period of Great Depression. So, the government of USA imposed prohibition. But there was one individual who decided to use this prohibition to make good money. He started a laundry business. In the name of laundry business, what he was doing, he was selling liquor. And later, the proceeds of this illegal sale of liquor was converted into white money through various banking channels and various other methods. From this particular event, the word money laundering has come into the lexicon, the dictionary of regulators, governments and others. If I correctly remember, the person who was doing this laundering was Al Capone. Name not important. But anyway, but as far as this law is concerned, in late 1980s, there was significant discussion, debate over the link between drug trade and money laundering. The money which is generated from drugs are laundered, converted into white, and which is not only financing terrorism. Remember 1979, Mujahideen, 1980s, Al-Qaeda. This is the period where international terrorism as a concern created sleepless nights for the governments and the international organizations. So, drug trade, proceeds of crime, money laundering. And this proceeds of crime converted into laundered money is used for financing terrorism. Not only for, it has created significant chunk of black money in the system. And this black money essentially means destabilization of economy. So, large presence of black money will lead to destabilization because the monetary authorities or the financial authorities' actions and decisions will not have any impact because of the presence of black money. And not only that, there have been instances of significant amount of black money present which have resulted into destabilization and even threatening the sovereignty of nations. In order to address this linkage between drug trade and destabilization of economy as well as violation of sovereignty of nations, at the international level an organization was set up, FATF, in 1989. Later the United Nations have brought significant number of conventions. And one important objective of these conventions was the national governments, national legislatures should enact a corresponding law to prevent the money laundering owing to drug trade. So remember one thing, the genesis, the rise and debt trade, the history of this PMLA in India is linked with drug trafficking. Drug trafficking. Now what is the scope of PMLA today? I am going to show you the kind of offences which PMLA deals with today. Ideally, drug trafficking. So, ideally, laws like NDPS, Narcotics, Drugs, Psychotropic Substance Act, NDPS should have been a part of PMLA, or some other IPC offences, waging war against the nation, etc. So, such stringent, serious, very serious offences should have been part of PMLA, money laundering. Remember one thing, money laundering will happen only when a crime is committed. Money laundering is not a standalone crime. It means that, for example, the Enforcement Directorate, which is supposed to investigate the offence of money laundering, can only start investigating when a crime has taken place and when any other agency has registered an offence. For example, police. There are provisions in Indian Penal Code dealing with drugs, drug trafficking and drug trade. So if the police registers an FIR, on the basis of that, PMLA, the Enforcement Directorate, can start an investigation. So Enforcement Directorate, which is the agency which is implementing PMLA, cannot start an investigation or inquiry without being an offence registered by the concerned agency. And those offences are known as predicate offences. Predicate offences or scheduled offences. Because there is a schedule of PMLA, like there are schedules in the Constitution. The schedules of the PMLA deal with those predicate offences. If CBI, the Customs or the NCB or even SFIO, the police, if they register such cases and if such offences fall in the schedule, then the ED can start investigation. So money laundering is not a standalone offence. It depends upon, contingent upon the predicate offences being committed and registered. Now, ideally the predicate offences should have been limited to those very serious crimes, drug trafficking, waging war against the country, etc., etc. Normal offences, ordinary offences should not have been included in the part of PMLA. You will understand why. One important reason is history of PMLA, drug trafficking. But if you see the predicate offences, in PMLA, you will find that the PMLA seems to have lost its way, lost its scope, lost its focus. Overview of scheduled offences. See, I am going to show you the schedule of PMLA. Part A, you see the schedule. 120B, criminal conspiracy. 121, this is fine, waging war. Section 21, fine. Counterfeiting government stamp, making, selling instrument, counterfeiting, murder, attempt to murder, how a murder is how a murder should be should be an offense under money laundering. Murder can be committed for extortion, kidnapping, etc. Then you can have. But simply a murder cannot be an offense under PMLA. Not only that, if you find these things, kidnapping for ransom, fine. Robbery, dacoity, dishonesty, receiving stolen property, habituating stolen property, concealment, cheating. Cheating, how cheating? The point I am trying to make is that the entire Indian Penal Code seems to have been included under PMLA. Significant number of offences which are under the schedule of PMLA do not have any linkage with money laundering. So did they add all this in PMLA 2020 amendment? No. Through a series of amendments. 2005 was the date when the PMLA was enforced. 2009, 2012, 2018, 2019, 2023, etc., etc. NDPS, fine, we can agree with that. But what about this? Explosive substance. UAPA have been added. Fine. Arms Act. Wildlife Protection Act. Why Wildlife Protection Act? There can be some provisions under Wildlife Protection Act which may have linkage with the money laundering, but not all. ITPA, Prevention of Corruption Act. This is a very serious issue. Prevention of Corruption Act was added in. Now, a clerk in an office taking bribe, how is that linking with money laundering? The point is that money laundering, see, strictly speaking, money laundering will happen only when you convert it or try to convert. Let's say I have taken bribe and kept in my home or deposited, not deposited, just kept in my home. So, I did not try to convert into white. So, money laundering did not happen. But remember, as per the amendments, subsequent amendments to PMLA, even taking the act of bribery is also money laundering. It is not necessary that you convert it. If you have the proceeds of crime, that's enough. Whether you try to convert, you actually convert, does not matter. Having proceeds of crime is enough. And not only that, this PMLA is applicable to even prior to the act. PMLA is 2002. It came into force in 2005. Now what about those offences? What about those properties which people acquired through money laundering? Will PMLA apply to pre-2002 activities? There is something known as continuing offence in PMLA. Continuing offence. It simply means that even if it is a 19th century property, 20th century property, PMLA will be applied. Prevention of Corruption Act. The fundamental idea behind Prevention of Corruption Act to bring good governance, to bring efficiency. Now we have added entire thing here. Now this is one of the major reasons why large number of MLAs and MPs and even ministers are being proceeded against under PMLA. Just taking 100 rupees by a traffic police constable will come under this. The point is that why am I telling you all these things? The fundamental idea behind PMLA was drug trafficking and destability of nation, sovereignty. That is the linkage, which means we cannot add such offences, ordinary offences, which can be dealt by normal law under PMLA. The PMLA should be focusing on very serious crimes which threaten the sovereignty of the nation, which create economic problems, challenges. So, by including all the sundry offences, what you have done two things. One, you undermine federal principles. CBI requires general consent in general. Police, law and order, public order is state subject. Now what will happen here? What will happen? The police registers a complaint for murder. Who's supposed to investigate it? Police. Now, what the enforcement director will do? FIR is registered. So, then they have the authority. They will start their own investigation. Even though there is no actual money laundering, just registration of an FIR by the police will result into investigation by enforcement directorate. Now that enforcement directorate will reach the state. We'll call each and everybody. We will see one major problem later. The problem is that this violates federalism because this PMLA provides authority to enforcement directorate to start investigation provided there is a predicate offence. Predicate offence? Now the police, you know that crimes are there in the country. Police and public order state subject. The point was, historically, the idea is to deal with such very serious crimes. Hence, the predicate offence, its scope was very narrow. Through subsequent amendments, almost all the acts and the IPC offences have been included in the schedule, which essentially mean the enforcement directorate will be able to start an investigation, whether it is Copyrights Act, whether it is Wildlife Protection Act, whether it is IT Act, whether it is various IPC offences including murder, conspiracy, etc. There are multiple issues. The point is that this enlargement of scope essentially meant two things. One, dilution of focus. Second, violation of federalism. Apart from this, there are some other fundamental issues which affect the working of PMLA. So, first issue was the historical focus. Historical focus was gone because of the enlargement of the scope. Second is politicization of PMLA. Now, how this politicization happened? It is held that the PMLA provisions are being used against the opposition parties in the world, in the country. In fact, the Indian Express has conducted a study. According to them, out of the total PMLA cases registered against politicians in India, 85% of them are against opposition parties. And it is also held that the enforcement directorate only focus on opposition ruled states and target the opposition leaders. It is also said that the arrest of a sitting chief minister is arrested in Delhi under PMLA. One chief minister in Jharkhand had to resign, then he was arrested. Large number of people, large number of politicians have changed their parties because of the money laundering PMLA proceedings. And once they have changed their parties, then PMLA proceedings either dropped or investigation does not progress. Large number of examples have been given by people. The Chief Minister of Assam, Himanta Biswa Sarma, when he was in Congress and changed to this party, hardly anything known about his case. Suvendu Adhikari, West Bengal, in camera was seen taking money in Narada scam. He changed party. Now nothing is happening. Ashok Chavan, Praful Patel, Chagan Bhujbal, Ajit Pawar, you name it. That is why it is held that the PMLA is weaponized by the government and the ED to promote political interest, to undermine the opposition unity, to break parties. Not only that, electoral bond. There have been multiple reports which have pointed out that after the raid of Enforcement Directorate, after the initiation of PMLA proceedings, companies have started donating to one political party. So it is felt that the threat of PMLA proceeding have forced the companies to donate under electoral bond. Thanks to Supreme Court for that, this idea, entire gamut of issues affecting electoral bonds have come out, although belatedly. But the most important thing is structural. The most important issue, most important problem that affect the PMLA is structural. What are the structural issues? Section 50 of PMLA. Section 50 of PMLA, what does it mean? Section 50 of PMLA says it's a kind of notice that is issued to a person to join investigation. Section 50 is for summoning an individual by Enforcement Directorate. But the most important issue here is the person who is being summoned does not know what for he is being summoned. Simply a notice will come to me. It will be written, you are being summoned under Section 50, under PMLA proceedings. For what? What are the allegations against me? No, silent. The person who is being summoned do not know whether the person is an accused or a witness. Very important. Why? If you are an accused in a case, then Article 20. What is Article 20? Self-incrimination, protection will be available. But Section 50 says it is not clear. It does not mention whether you are an accused or a witness. Not only that, you have to speak the truth when you are being summoned. If you do not speak the truth, then you will be proceeded against, and whatever you speak under Section 50 summon proceeding will be used against you during trial. This is unlike what happens in CRPC. Criminal Procedure Code. Criminal Procedure Code is the procedure. What is this procedure? Procedure. Where this procedure is Article 21 procedure. What does Article 21 says? No person can be deprived of his or her liberty or life without procedure established by law. This is the procedure established by law, CRPC. For example, if it is a non-heinous crime, a crime for which the sentence is 7 years less than 7 years, Section 41A of CRPC, from June or July you may have a different BNS, not CRPC, whatever that might be. For the time being, CRPC 41A says that a notice should be issued to a person to join investigation. That's the procedure. That procedure, a fair and reasonable procedure is given. Section 50 is silent on the procedure. It simply says you are summoned. The person who is summoned does not know whether an accused or witness. He does not know the allegation against him. So he does not have any chance, any choice to defend himself. If he knows he is an accused, then it is for the ED to prove that I am guilty. An accused has right to remain silent. But here you cannot remain silent. You want to speak everything you should know, and whatever you speak will be used against you in the proceedings. It patently violates the Criminal Procedure Code. This Criminal Procedure Code is given because to protect the life and liberty of people, because your life and liberty cannot be taken away without procedure established by law. No fair and reasonable procedure is given under Section 50. Not only that, this fair and reasonable procedure is absent. Summoning, arrest, seizure, search, whatever the ED does, in almost all things, a fair and reasonable procedure is not provided, which means abuse, misuse, violation of fundamental rights for people, a patent violation of Article 21 of the Constitution. Structural. Not only this, Section 19. Section 19 of PMLA, what does it say? It says that grounds of arrest of a person. Grounds of arrest should be communicated. Grounds of arrest. Summoned, then arrested, then the grounds of arrest should be communicated as soon as may be. As soon as may be should be communicated. Now the question is, what is the mode of communication? Mode of communication. Oral communication, written communication, what kind of communication? Because you should know why you are arrested. Article 20, which 22. Article 22 says what? As soon as may be should be informed, should have the right to consult a lawyer. Isn't it? So, Section 19 says, inform the grounds of arrest. What's the mode of information? Because if you give it orally, then what will happen? No proof is there. It can be changed. To understand the nuances of the Section 19, it is necessary to understand the Supreme Court judgment. There is a Supreme Court judgment, Vijay Madanlal Chaudhary. Vijay Madanlal Chaudhary versus Union of India 2022. Unfortunately, this judgment has upheld the constitutional validity of PMLA. Not only upheld, but upheld all the draconian provisions under this PMLA. Justice Khanwalkar was the judge who presided over this case. It is the same Justice Khanwalkar who is the Lokpal today. So, as per Vijay Madanlal Chaudhary, which upheld these provisions and the other provisions you will see as valid, was silent upon the mode of communication. But later one judgment came, Pankaj Bansal judgment. In the Pankaj Bansal case, the Supreme Court of India said the ED has to provide information within 24 hours and that information should be in writing. And if the information is not, I am coming to that, Akshida. Burden of proof, Section 45, I will come to that. Pankaj Bansal, Supreme Court held that grounds of arrest should be communicated at the time of arrest, that too written. And if these two things are not fulfilled, then the accused will be set free because the arrest will be deemed as illegal. And the Pankaj Bansal judgment said this verdict will also apply retrospectively, although it did not say that way. Henceforth, in other words, according to Pankaj Bansal judgment, if grounds of arrest is not communicated at the time of arrest and not in writing, then the arrest will be illegal. And many high courts in the country have interpreted this Pankaj Bansal judgment to mean that all those arrests previously, before Pankaj Bansal judgment, where the grounds are not communicated at the time of arrest or written communication is not provided, have been held invalid and people have been set free. But one Supreme Court bench headed by Bela Trivedi, this bench in their own wisdom, which I do not understand and appreciate at all, in their own wisdom, interpreted this Pankaj Bansal in a different way. According to them, Pankaj Bansal judgment will not apply to previous cases. Retrospectively, it will not be applied. Not only that, this Bela Trivedi bench judgment in the case R.K. Arora, the case is R.K. Arora. In this R.K. Arora case, this bench in their own collective wisdom held that Pankaj Bansal will not apply retrospectively. Not only that, it said at the time of arrest need not be provided. At the time of arrest, yes, at the time of arrest, you provide oral information. Who? The ED. And within 24 hours, you can provide written communication. This has further eroded whatever scope is left for individual liberty. Because 24 hours is significant time to think about what should be the ground to manufacture. They can change it. But as of now, this is section 19 is also a problematic area, because ideally Pankaj Benfeld judgment should hold, which means at the time of arrest you should provide the grounds in writing, because that document will help the accused to challenge the arrest, to get bail, etc., etc. But one thing is clear, right from summoning till trial or acquittal or conviction, you will remain in jail in general. In PMLA, bail is the exception, jail is the rule. But in almost all the criminal codes, criminal law, especially, excluding this UAPA and others, stringent, although still there are problems there that we will see whenever any topic comes on this UAPA. Wherever this norm is applied, bail is exception, jail is the rule, then the rights of individual, fundamental freedoms of individual will be affected. It provides huge scope for misuse, abuse, lack of accountability of the concerning agency, here the Enforcement Directorate. Not only this, another problem is ECIR. Enforcement Case Information Registration. This is similar to FIR. First information report, which is the beginning point of starting of investigation by the police. This FIR will have the details of offence, time, place, etc. And the person who is accused or witness, everything will be there. So this FIR as a matter of right should be provided to the accused. For that he can challenge it. But ECIR, Enforcement Case Information Registration or report, the ED will not provide you. So when someone is given, they will provide a file noting, ECIR file noting, etc., XYZ. But what exactly is the document, you will not get. So the point is that you do not know the allegation against you. You do not know why I am being summoned. Without ECIR, you cannot challenge your arrest. Without ECIR, you cannot go for anticipatory bail. Anticipatory bail means you apprehend that you may be arrested, so you are taking bail from court. After arrest, it will be regular bail. Before arrest, anticipatory bail. Now, in order to get anticipatory bail, you should know, you should satisfy the court. See, this is the ECIR and I am an accused. But I am saying that I am contesting this. But you don't have anything with you. How will you get anticipatory bail? The judge will say, "Kahan hai tumhare paas?" No. You will get an ECR only after 60 days, because within 60 days, the ED has to conduct its investigation and file a complaint. Then you will get ECIR. Now, once the complaint is filed, then you will have to take bail, regular bail. Now, the problem is regular bail. I am coming to your question, PMLA, Akshita, not your question, your statement. Regular bail in PMLA is nearly impossible, because section 45 of PMLA says, section 45. Section 45 of PMLA has a twin condition for bail. Twin condition. All these two conditions should be satisfied. Condition number 1. The public prosecutor should be given an opportunity to be heard before granting bail. So public prosecutor means government. So generally he will oppose. That's one. So there are multiple cases where the court can grant bail even when the public prosecutor is not there, or even he is not given opportunity. But here it is said that without the opportunity being given to the public prosecutor to oppose, like you see what is happening in Kejriwal case, in this Manish Sisodia case, etc., etc. Always the public prosecutor oppose it. No, what is the second condition? Second condition is that the judge should reach a reasonable conclusion that the accused is not guilty of money laundering and will not commit the crime in future. Now, how will you prove a person guilty or not? Only after trial. When the trial is conducted, witnesses are examined, charges are framed, then the court will, on the basis of evidence, will come to a conclusion that you are guilty or not. On the threshold, when the bail application is heard, how you can conclude that the person is guilty or not? The decision on guilty or not guilty is after completion of trial. Now it is only bail. So this condition is virtually impossible to fulfill. Condition what? The judge should reach a reasonable conclusion that this person is not guilty of the offence. Not only that, he will not commit in future. How can the judge guarantee that he will not commit? The twin condition of bail in section 45 PMLA have turned the jurisprudence, bail jurisprudence, criminal jurisprudence on its head. It has reversed the burden of proof. In ordinary criminal laws, the burden of proof is on the prosecution to prove that this person is guilty. Now here it is for me, the accused, to prove that he is not guilty. Now how will you prove? You don't have access to these things. You will get access only, you can prove whether you are guilty or not only when the trial is completed. Now when bail is heard, it is pre-trial. Remember one thing, trial in PMLA is a very lengthy process. It takes lot of time. So as long as trial is not completed, bail will not be given. You see, entire process you see, anticipatory bail you can't get because ECR is not available. So you don't know. Then you are arrested. Even when you are arrested, you cannot challenge because ECIR will not be given to you. So 60th day or within 60 days, the ED will file a complaint in court. That is investigation completed investigation. Now once investigation completed, then you should apply for regular bail. Regular bail you can't get because section 45. You can come out of the jail only when trial is completed, whether you are found guilty or not. Remember, 7 years is the maximum punishment under money laundering. So people are in jail for 3 years, and what if the person is acquitted later? What will happen to the person's liberty? Trial in PMLA is very slow. Since 2005, more than 5,900 cases have been registered by the ED under PMLA, out of which only 25 cases have been completed, disposed of. Under 25, 24 cases ED was able to get conviction. 5,906 out of that 25 cases, 0.42 something conviction rate. But what ED is saying, we have 96% conviction rate. How? Out of 25, 24. Trial, conviction, everything is delayed. People will suffer in jail. Structural problem. The PMLA as a law has lost its way. Because the very purpose for PMLA has not been served. And the Supreme Court of India has enabled this losing the way of PMLA. And the government also, because the parliament has amended this law multiple times. And because of that amendment, the power of the ED have been what? Enhanced. And one important judgment in between was the Supreme Court in 2017. Nikesh Tarachand Shah, in this judgment, Supreme Court have struck down this tuning condition. Which one? The section 45. Justice Nariman. But later Parliament amended the PMLA, which essentially restored this twin condition. Vijay Madanlal Chaudhary, Justice Khanwalkar, upheld the entire PMLA. According to him, PMLA is not a penal statute. Penal means punishment. A law which has 7 years imprisonment is not a penal statute, according to the judge. According to the judge, the enforcement directorate officers are not police officers. If they are not police officers, then CRPC will not apply. But what ED is doing? They are actually police officers. Summoning, arresting, investigating, seizure, prosecution, everything they are doing. So they should be police officers. If they are police officers, then the CRPC will apply. CRPC will apply, which means the procedure, safeguards under CRPC will apply to ED proceedings. In fact, PMLA has a section, section 65 of PMLA. Section 65 of PMLA says, if there are contradictions between PMLA and CRPC, PMLA will prevail. But if there are no contradiction, then CRPC will prevail. Then CRPC will apply. If there are contradiction between PMLA and CRPC, then PMLA provisions will prevail. If there are silences in PMLA, if there are no contradictions between CRPC and PMLA, then CRPC will apply to PMLA. ECIR is an internal document, according to ED, internal document. This does not have any procedure in the sense that how you should summon, what should be the content, etc., etc. CRPC clearly says the procedure of dealing with arrest, investigation, summoning. PMLA is silent. If PMLA is silent on this aspect, shouldn't the CRPC apply? It should apply because there is no contradiction. Yes, there is no contradiction because there are silences in PMLA. No fair reasonable procedure is given, summoning, arrest, arrest, seizure, etc. So procedures are not there in PMLA. But there is a provision in PMLA section 65 which says that if there are contradiction, then PMLA will apply. PMLA will prevail. No contradiction, then CRPC will apply. Which means because of the absence of procedural safeguards in PMLA, the procedural safeguards of CRPC should apply. But Justice Khanwalkar in his wisdom said this will not apply because ED is not police officer. The Vijay Madanlal Chaudhary has undermined the fundamental rights of people in this country. Vijay Madanlal Chaudhary has provided extreme power to the Enforcement Directorate. Vijay Madanlal Chaudhary has threatened democracy in this country. Vijay Madanlal Chaudhary undermined the federal principles in the nation. But not only this, a review petition was filed against Vijay Madanlal Chaudhary. Although not all parts of the judgment will be reviewed, some parts of judgment, especially section 45 and with respect to ECIR, these particular issues have been accepted for review. We are in 2024. The review has not been heard. The Supreme Court of India, Chief Justice of India, is the master of roster. Being the master of roster, ideally, he should be using his power of master of roster to do such duties which he is expected to do. There have been one attempt, another, by the retired Sanjay Kishan Kold, SK Kold. But unfortunately, critics say, or the commentators say that those two judges which were there in his bench did not show any enthusiasm to review or to address this issue of PMLA. As we are speaking, review is not heard. But the 3 judge bench which was hearing the case, to hearing because whether this entire judgment should be referred to a constitutional bench, etc., that was the idea behind that. Now they will hear the case when? July 2024. Election will be over then. The Supreme Court's role in making PMLA losing its way will not be written in golden letters when the history is written of the court. The Supreme Court has shown great commitment not to the rights of people but to the legislative wisdom of the parliament. When people are approaching the court under Article 32, PMLA, court is saying go back to High Court, go to trial court. I am only concerned about the officers who are manning ED. It is those officers who studied UPSC, cleared UPSC and became officers, especially Indian Revenue Service officers, IRS. You can say that the administration work under the political system. The one major problem might be the ethics paper might not have been there when they were writing the examination. Whatever that might be. The point is that PMLA seems to have lost its way. According to PDT Ajari, the then Secretary General, he says that PMLA lost its way because PMLA should have been looking at those serious crime. See the history, now the present. Out of 5,900 cases, very poor conviction. Trial is delayed. Targeting opposition leaders. When leaders change party, no case. It is necessary to bring back ED to its original mandate. For that, a structural overhauling of PMLA is necessary. Provisions as well as the schedule. Pruning the schedule is necessary. Pruning. Limiting the scope of schedule is necessary. Safeguard should be built. CRPC provision should be applied to PMLA. The Directorate of Enforcement should be made a statutory body, if at all. Not under the control of government. Remember that then this Director Mishra, he has been given extension. Despite the Supreme Court asking to replace him, the government said we want him. After that, Supreme Court has to say from this day midnight he will not remain. That to the extent the Supreme Court had to go. As of now, only an acting director is there. After Mishra ji, no original, no proper director is appointed. Acting director, in charge director. It is high time that the Supreme Court either provide bail to these people so that they can campaign, they can contest election. So ultimately the idea is that you are arresting people in the middle of the election. The Election Commission of India should take note of this happening. I don't think they will. Whatever that might be. It is necessary that the entire system of PMLA requires to be changed, amended, modified. Money laundering is a serious issue. But you should focus on money laundering, not on other political interest. You want to ask anything, you can. Thank you so much.